All right, ladies and gentlemen, thank you for joining us today on our webinar on anti-dumping and countervailing. Talking on the webinar today will be myself, I'm the VP of Sales here at TRG. We also have Rachel Bowman. Rachel's our claims manager, and in her years of experience, she's seen almost everything under the sun, so we're really lucky to have her experience. Also, we have Meredith. She's our marketing manager, and I'm willing to bet that of any marketing expert in the country, she knows more about U.S. customs bonds. And finally, Josh Froberg, he's our Vice President of Underwriting and a licensed customs broker. So again, he's been talking with clients for, I think, 15 years now. And as an underwriter with a licensed brokerage license, he comes with a unique perspective. A little bit about Trade Risk Guarantee. We are an insurance agency in Bozeman, Montana. We've been in business since 1991. We live in the niche world of U.S. customs bonds and cargo insurance. We like to celebrate our direct to importer business model. We feel this allows us to have the best communication possible with our clients in the importing world and hopefully really competitive pricing. We have over 10,000 U.S. customs bonds and cargo insurance clients, and we love hosting these types of webinars. You can find us on YouTube. Go to YouTube, type in Trade Risk Guarantee -TRG, and you'll find our YouTube channel. Trust me, this material is more exciting than Netflix. If you spend the time to watch these videos, they're all free. Be sure to click on the thumbs up and be sure to comment on each of the videos. It does make a difference. Throughout the webinar, you'll be able to type in questions. There's a wide spectrum of attendees at this webinar, from newer importers to people that have been doing it forever. So we try to make the vocabulary spelled out, but if there's any talking points or any thoughts at all, don't hesitate to type in the questions. We need communication with the importing community to make these webinars interesting. As a quick reminder, this webinar is for educational purposes only and does not constitute legal advice. Now I'm going to hand it over to Meredith.
All right, thank you, Travis. In today's webinar, we're going to be going over 4 primary topics. First, we are going to have a quick intro to anti-dumping and countervailing, as well as define a few terms that will be used throughout the presentation. Then we're going to dive into some of the added risk of importing goods subject to anti-dumping and countervailing. Then we're going to go over a real-world anti-dumping case. And finally, we have some advice for the importers that deal with anti-dumping and countervailing regularly. So let's get started with a brief intro and define some of those terms. All right, first off, what is anti-dumping and countervailing? Well, for the sake of this presentation, we're only going to briefly define these 2 terms, since most of you are probably already familiar with them. However, let's get into it. Anti-dumping is a protectionist tariff imposed on foreign imports believed to be priced below fair market value and causing harm to the domestic market. So these are goods that are typically being brought into the United States at a price lower than it costs to produce them in the country of origin, or at a price that is lower than it would be sold in that country of origin. Now, as for countervailing, it is also a protectionist tariff imposed on foreign goods believed to be subsidized by a foreign government and causing material harm to the domestic market. The big difference with countervailing is that the foreign government is subsidizing the production of the commodity, allowing the commodity to be sold at a price below the cost to produce it or the cost it would be sold in the country of origin. The intent of both anti-dumping and countervailing duties is to raise that end price of goods back to fair market value. Now, if you want a more in-depth explanation on anti-dumping and countervailing, we do have 2 previously held webinars on the topic on our YouTube channel, and we have a more recently published short video defining these 2. We also have a lot more shorter videos on the topic coming out in the next few months. Now, another term that we will be using a lot throughout today's presentation is liquidation. When it comes to importing into the United States, liquidation is the final assessment of money owed to customs based on current knowledge of duty rates and the value of the imported goods. Liquidation typically occurs 314 days after the date of entry. And this is when CBP really is looking over your entry to ensure that everything has been filed and paid correctly. If your entry does not liquidate within that 314-day period, it may auto-liquidate at 365 days. And liquidation is typically the final phase of importing for an individual entry. Throughout this presentation, we will be talking a lot about risk and how it can stay open for an extended period. In terms of importing, liquidation typically marks the end of that risk for a specific entry. Now, there are a few reasons that your entry may not liquidate within the normal time frame, and one of those reasons is that the liquidation is suspended. Suspension occurs when CBP pauses the standard liquidation timeline to allow more time for additional information to be submitted. When it comes to entries that involve anti-dumping or countervailing, the liquidation is automatically suspended since they take longer to liquidate. We will be getting into this much more in the following slides. Now, I have already used this term, the term entry, quite a few times, and that is a pretty broad term when discussing importing. In today's presentation, we will be primarily discussing entries that involve anti-dumping and countervailing. However, we will also touch on standard consumption entries a little bit. A consumption entry contains goods entered into U.S. commerce, whether to be sold to consumers or for business or personal use. These do not include items to be temporarily imported or items for manufacturing or re-export. Anti-dumping and countervailing entries are a type of consumption entry, but they use a different entry type code for customs reporting purposes. That code is 03, while the code for the standard consumption entry is 01. And finally, throughout this webinar, you will see the use of the acronym ADCV. This acronym stands for anti-dumping and countervailing. It is used as a shorthand and can sometimes include the D on the end to be ADCVD, and that D just stands for duties. Sometimes you'll hear this kind of used interchangeably. Just know that if somebody is, saying verbally ADCVD or it's written on the slide, we are referring to anti-dumping and countervailing. Okay, I'm going to go ahead and pass the mic over to Rachel so she can tell you all about the added risk of anti-dumping and countervailing.
Thank you, Meredith, for those definitions. So with anti-dumping and countervailing, you have the potential for adjustable duty rates. The initial ADCV duty you pay acts as an estimated deposit, and this is important. It is considered a deposit by customs and is not final. The final ADCV duty rate is subject to change upon completion of the investigation conducted by the Department of Commerce, which you'll see abbreviated as DOC, and the International Trade Commission, which you'll see abbreviated as ITC. The final duty rate determined can be exponentially higher than the deposit rate that was paid, which would result in additional monies owed to customs. And if that's the case, they'll send that to you in the form of a supplemental duty bill. In fact, there's no limit to how high this final amount can be. We've seen the amount easily be over 100%. That's not to say that's always the case. We have seen entries liquidate at the same rate that was paid or even get refunds. But we as the surety and you as the importer is going to be concerned with additional monies owed to customs.
Rachel, will customs take into consideration whether or not the goods have been sold?
No.
Okay.
This is something that needs to be handled at the time of liquidation, which, as we'll discuss further into this presentation, can be years into the future, regardless of the status of those goods. So at the time of liquidation, the final anti-dumping and countervailing duty amount owed is determined and due to customs. And you'll hear me sometimes in this presentation probably refer to anti-dumping and countervailing simply as anti-dumping. I deal a lot with this topic, and that's kind of my short-term vernacular. So if you hear me say anti-dumping, just know I'm referring to both. So let's look at a simplified hypothetical example of these adjustable duty rates. Say an importer pays 10% anti-dumping countervailing duty at the time of entry. By the time the entry is liquidated, the final anti-dumping and countervailing duty has been determined to be 150%. And this is after the internal investigations are concluded by the DOC and the ITC. At that time that the liquidation instructions are posted, the importer will then have to pay the additional 140% in order to reach the 150% duty rate. We'll discuss this timeline a little bit more now. So anti-dumping and countervailing entries can take multiple years to liquidate. The liquidation process for anti-dumping entries is suspended indefinitely while this investigation is carried out. The investigation process can take multiple years and is a back and forth process between the DOC and the International Trade Commission. This means that the liability for the entry will remain open for multiple years until that investigation is concluded and the entry is liquidated. This affects your customs bond because the bond is in place to guarantee payments to customs up to the full bond amount over the course of a calendar year between the bond's anniversary dates. Therefore, when entries are suspended for multiple years, the surety's liability also remains open from past bond periods and can result in aggregate liability greater than the amount of the bond. We refer to this as stacking liability, and we do have some other webinars that discuss the stacking liability in more detail. So if you want to find those, you can find them on our YouTube channel. So here's a graphic representation of that timeline. Importers could have made the original entry back in 2015 and then pay the 150% final duty when the entry liquidates, say, in 2022. That's 7 years later. You will also see a visual representation here of a standard entry. That's the one on this graphic. And you can see how much shorter that liquidation time period is between the date of entry and the date of liquidation. There also can be multiple anti-dumping countervailing entries made in the same year, and then these would liquidate higher in the 2022 timeline. Here on this graphic, you can see that there were 5 entries made in 2015, and all of them liquidate in 2022 at the date of liquidation, all with that 150% duty rate. And this generally is because these investigations are subject to what we refer to as periods of review. And these are determined and specific to the investigation itself, and usually encompass a full year period where any of the entries subject are liquidated at the same time.
So Rachel, in 2015, they make the anti-dumping countervailing entries. In 2022, they liquidate at a higher rate.
Mm-hmm.
How is the importer notified that they owe more money?
They would get a supplemental duty bill in the mail for each of the entries, and that comes directly from Customs and would be from the Department of Revenue.
And it goes to
the importer.
And
the surety is notified as well.
So the insurance company underwriting the bond is also notified?
Correct.
Okay.
So let's take a look at a real world example of an anti-dumping case. So in this case, there were entries of honey from China made in 2003. The liquidation of these entries was suspended pending additional investigation and litigation. And there was a lot going on the back end of this case. Domestic importers as well as the exporters in China were involved in the discussion of this honey case. The entries eventually were liquidated in 2019 with an increase in anti-dumping duties. So that's 16 years later. For this case, the importer did file a protest of the liquidation, which was suspended pending even more litigation. And that's been suspended for the last 3 years, meaning this is still unresolved and will not be considered fully resolved until a decision is issued on the protest and any money owed to Customs is paid. So you can see how, and this is a drastic example, you know, it's not incredibly common, but it is something that we have seen. So now let's talk about some advice for the anti-dumping importer. Our number one piece of advice is to keep your documentation in order. Customs puts a lot of responsibility on the importer of record in maintaining proper documentation for anti-dumping entries. We have a specific case here at TRG where an importer was using multiple company names under the same EIN number, same tax ID number, and they were involved in an anti-dumping investigation. One of the entities using the same importer number had received a lower manufacturer specific rate, and because they used a different company name, Customs determined that they no longer qualified for that lower rate and they have to pay the higher countrywide rate for the entries. So this is an instance where proper records were not kept, and it's become harder to convince Customs that they should have qualified for that lower rate. In this instance, also, the importer does not have any of their own records, and they have to rely on their broker to provide all of the documentation for them, where if they had kept all of that documentation for themselves, it would be a lot easier to resolve the case.
So I think another thing that you're kind of saying here is it's keep documentation in order, but also consistent. In that example, you know, it really also was the use of the different company name that kind of put them in even more hot water. So that's just kind of another thing maybe we should have put on the slide is keep it in order, but also make sure you're using consistent information. Customs will consider even like the slightest difference in a name, a company name, as potentially a different company, even though the EIN is the same.
Yeah, Customs is very statistical, and they want to keep the records as accurate as possible. So another piece of advice we have is to stay informed on anti-dumping and countervailing cases that may impact the goods you import. We have a few items here that we think are important for importers to keep a track of. There's plenty more, but these are kind of the key things that we have determined. So the scope of the case provides a detailed description of what commodities will fall under an anti-dumping and countervailing duty ruling. And this description is incredibly detailed. For example, aluminum extrusions, they go down to the millimeter to determine whether they're subject to anti-dumping or not. HTS codes can be listed within the scope, but they are just for reference. The description of the scope is what is enforced and not bound to any one HTS US code. So the classification that you're using on your entries does not preclude you from being subject to anti-dumping. It is the description in the scope. Case numbers, every anti-dumping and countervailing case is assigned a unique case number. Knowing the case number will help you keep track of the case and look it up in the ACE portal or the public search portal. And here we have a link to a search site that is published by the International Trade Commission, where you can use keywords, case numbers, country of origin to search for specific commodities and cases.
And we'll be including this link in the follow-up email, so don't feel like you need to jot this down right this second.
Another thing to keep track of is the key dates. Anti-dumping and countervailing investigations have a lot of dates involved, but ones that you really should pay attention to are the preliminary and final determinations of the duty rates, the duty orders themselves, and when the first annual review date is.
And you know, Rachel, you talked about the scope, and within that you talked about classification, and part of that is, I mean, as an importer, because of the Modification Act, the Customs Modification Act of '94, you're responsible as far as U.S. Customs is concerned. You have service providers that you can lean on, and it should be part of your protocol to, one, this is very soft information, but it doesn't hurt to ask the supplier if their goods are subject to anti-dumping or countervailing. The supplier is under no obligation to give accurate information, but it's a good place to start. Second, work with that customs broker. Before anything new is purchased, identify whether the customs broker would say it's possibly subject to anti-dumping or countervailing or not. That's a good place to start.
Yeah, your logistics providers are there to help you. Ultimately, like we said, Customs will look to the importer of record as the ultimate source of knowledge, but your logistic providers should be able to offer a lot of advice in this. And third, to avoid anti-dumping and countervailing altogether, switch to a different supplier, change countries of origin. We understand that this is quite a logistics shift and kind of a last case or last chance scenario, but it is a way to avoid the anti-dumping and countervailing investigations. I did also mention a little bit about manufacturer-specific rates versus countrywide rates. Rather than changing suppliers altogether, you could look for a supplier within that country that has participated in the investigation and got themselves a specific rate that tends to be a lot lower than what the countrywide rate is. And that would be a way to mitigate some of the additional duties you may end up paying. And with that, I'm going to turn it over to Travis.
Yeah, I guess I'm talking about communicating with your bond provider, because most often I'm one of the first people you talk to at our agency. When I started selling customs bonds in 2010, customs didn't have the transparency or the record keeping that they have now. They're better at their job, and they have more data to draw from. And quite frankly, you can't fly under the radar with anti-dumping or countervailing, maybe like you kind of used to be able to. And what that means is the bond is more important. These insurance companies, there's only a limited number of insurance companies that are approved to underwrite customs bonds. I'll say at this point, across the board, the insurance companies consider anti-dumping and countervailing toxic business. They want to avoid it. So if you're going to engage in this type of business, you need a strong agency that will communicate with you. If you have a bond in place and you've never done anti-dumping or countervailing, and you know you have an entry coming up that will be anti-dumping or countervailing, get on the phone and talk with the agency and give them a heads up ahead of time. They're going to see it. As Rachel mentioned earlier, the surety or the insurance company underwriting the bond is notified by customs when an anti-dumping or countervailing entry is made. Then the insurance company reaches out to the agency reaches out to you. It's better to have that conversation ahead of time rather than after the fact. And there are countless other talking points and communication and questions you can have with your bond provider. But long story short, too many companies out there consider the bond something that operates on cruise control. You just renew it every year. Why do I ever have to think about it? I have to have it. I don't want to know about it. I just pay for it. And to a large extent, many importers can get away with that mentality, but more and more anti-dumping is becoming part of the conversation. If you're related to anti-dumping at all, that's not the case. It's key. You can't import without this bond. So have rock solid communication with the agency that gets you that bond. That's the best advice I could give. Then talk to an expert. And this ties in exactly to what I just mentioned. As an agency, we've evolved, and we do have scenarios where we can possibly provide the bond with less heartache. Quite frankly, for many companies out there, placing collateral to keep the bond on file to continue to enter anti-dumping and countervailing entries is the cost of doing business. People don't want to hear that, but that's the reality of the fact. Now, as I just mentioned, TRG does have some approaches that may allow us to qualify some companies to get the bond without less heartache. We'd love to talk to you and see if we can make it work. Use that email right there, askanexpert@traderiskguarantee.com to reach out to us. And here we go. We're done with the material. We want you guys to submit questions. We have some typed in already. And we're going to give you another minute to type in that information. Real quickly, I want to talk about trade risk guarantee again, my favorite topic in the world. We got a good team of people here. We love talking with people. If you can't tell from this webinar, it's all about education and communication with you guys, the people that are on the hook with customs. We have our YouTube channel. For more information, we try to always be available on the phone, and we want to work with you on your customs bonds. Give us a call, reach out to us. We're here. Okay, right off the bat, this is a good question that we didn't really hit on. Where can you find information regarding an entry that was made as anti-dumping or countervailing? So I think, a lot of companies out there, they've been importing for a while, but possibly have never had an anti-dumping or countervailing entry. Besides your bond provider, which happens most of the time reaching out to you and telling you that the anti-dumping entry has happened. Where else can you find that information? And I think possibly maybe the best person to answer that is likely Josh. I mean, Josh, you're a licensed customs broker. You talk to importers all the time. Where can an importer find this information?
Yeah, so you'll want to check with your customs broker on that, and they'll be able to provide you with the 7501 form, or also known as the entry summary for that entry. At the top of the 7501 form in box 2, you'll find what the entry type was. And in most cases, if it's an anti-dumping entry, it'll be a type 03 entry type. It could also be a type 07 if it's also subject to quotas or visas. Once you've identified that that's the type 03 entry, you'll go through the 7501 form line by line in section 29, looking for a code that will start with either an A followed by 9 digits or a C followed by 9 digits. All anti-dumping cases start with the A. All countervailing cases will start with the C. Those will be followed by 3 digits of where the goods come from, so the country of origin, followed by 3 digits that identify the actual case that's involved. And then the last 3 digits of that line will either be 000 for the countrywide rate, or it'll be something besides 000, and that would indicate a manufacturer specific rate. Then if you look, there's a corresponding rate to that in section 33, and you can see what percentage of the value you're paying in anti-dumping or in countervailing duties.
All right, thanks, Josh. And, talking about the 7501, the entry summary, a lot of importers are very aware of the 7501. They have them all on file and have them handy. But also, a lot of companies aren't familiar with 7501 entry summaries. Meredith, do we have material that talks about the 7501?
Yeah, we do have a blog post that kind of breaks down a 7501, at least the major fields on that form. We don't really have anything yet specific to anti-dumping. Maybe that's something I need to create in the coming weeks. But it is kind of the crux document of your entry. Hopefully you're all familiar with it. It just becomes important of identifying, where to label it anti-dumping.
Okay, great. And we got a question here from Andy, and I'm going to read this. If you take out an importer bond that ends up being significantly larger than 10% of your duties, taxes, and fees during the bond period and have to post collateral equal to that bond amount, then could your surety allow you to lower your collateral or letter of credit by the excess amount before your entries liquidate? Okay, Andy, first off, we are one bond provider. We can't speak for everybody out there. And at the end of the day, it's not up to your bond agency, but the surety, like you mentioned in your question. It's up to the insurance company or the surety that underwrites the bond. Generally speaking, Rachel, you want to take this one?
Sure. So the liability is determined by the bond size on file when the entries are made. So unfortunately, in this scenario, as soon as the entry is made in that bond period, the surety would consider the full liability of that bond size to be outstanding liability. I can't speak directly to what the surety would allow, but I can tell you that the liability would exist for the full bond size, if that makes sense.
Andy, hope that's helpful. Reach out to us directly if you have additional questions. And what you're hitting on right there is it. Collateral is it's a tough subject, but let us know if you have more questions. Okay, Mohammed, we got, does importing products that have anti-dumping duties reflect badly on the importer? Hey, great question. I think what you're saying is, does it reflect badly on the importer from customs perspective? Now, and that's a great question. We have plenty of clients that have been importing anti-dumping and doing so professionally and well thought out, and as part of their business model responsibly. They've been doing it responsibly for a long time. They've accepted that there's additional cost, likely in the form of collateral, to keep the bond on file. They have impeccable record keeping. They know the regulations. And what I'm getting at, Mohammed, is just importing anti-dumping on its own is not necessarily you're not breaking the law. You're not doing anything wrong by customs view. But due to everything we had mentioned earlier in this webinar, the risk assumed by the insurance company that underwrites the bond just skyrockets compared to normal importing, standard 01 entries. So you're not doing anything wrong. And quite frankly, if you're a company that wants to participate in anti-dumping and countervailing entries, importing, go for it. But do it with eyes wide open. You're not gonna avoid the repercussions and just hope it goes away. So I hope that helps, Mohammed.
Yeah, as long as you're paying your estimated duties, taxes, and fees, including anti-dumping, and then as long as you resolve any potential bills that are issued, if those rates change to a higher rate, customs is going to consider you compliant, and your surety should as well.
But you can't ignore the fact that customs can adjust that deposit rate up astronomically, and that's what we tried to hit home earlier in the webinar. So there is a big financial risk that goes along with it. But I mean, Mohammed had a follow.
Okay,
our exams or any.
Oh yeah, the customs exams.
Does
no.
importing anti-dumping increase your chance for customs exams?
It shouldn't,
Rachel
as long as
says
you're
no.
doing everything in compliance. I mean.
Well, and we get that type of question all
Yeah.
the time. Customs doesn't tell us what triggers a risk of more exams. The manufacturer ID number, the country of origin, the type of goods, your track record with importing, those are all considered. So I don't know how to exactly answer that. Rachel says no. That alone, just importing anti-dumping does not increase your chance of exams.
Well, and I think it's important too for importers to remember, like, it might sound not great, but you know, customs is there to collect money. So, you know, importing into the US is the second highest revenue stream for the US. So they don't really want to stop you from importing. They want you to import, but they also just want you to pay the money that's owed to them. So if you're importing anti-dumping, as long as you're doing it responsibly and paying what you're supposed to pay, they want you to keep doing that, because I mean, again, doesn't sound great, but they ultimately make more money, right? So as long as you're doing it responsibly and following the rules that they have set forth, they're gonna let you kind of keep doing it.
So, okay, Lori, we got a good question from you. What is the impact of timing of liability if the initial entry is a warehouse entry, type 21, goods to be cleared at a later date? Josh, what do you have to say about that? Do you want me to reread it, Josh?
No, I think I understand it. So you bring in a warehouse entry that is going to be withdrawn at a later date. So as a warehouse entry, it would just continue on that bond period from when that was entered. Then there would be a separate entry made on the date that it's withdrawn. If it contains anti-dumping goods, at that time there would be another entry. That one would be suspended. The warehouse entry itself would liquidate once all the goods from that warehouse entry have been removed from the warehouse, either imported or destroyed or exported. So in terms of which bond period that would open up, it really depends on which stage of that it's in, whether it's still goods in the warehouse or if it's been withdrawn and constitutes an entry at a later date.
To, I guess, add to that, when the goods are withdrawn from the warehouse and an entry is made, if they contain anti-dumping goods, the entry type would be a type 3 anti-dumping for consumption entry, and then that would start that period of liability.
Okay, I think that is all the questions we have received at the moment. If you guys do have any additional questions, please send them in to us via email. We are going to go ahead and kind of talk about where you can contact us now.
Sure,
Travis, if you
right
wanna
there
go.
on our screen. We got our email address, marketing@traderiskguarantee.com. Earlier, we provided that email, askanexpert@traderiskguarantee.com. We got our YouTube channel. Please spend time on it. Please like the videos. Facebook group, if you're into that. Our website, blog. Blog's got plenty of additional great, quick educational materials. So that is a good place to visit. And
Yeah, thank you so much for attending. Again, if you guys have any additional questions, please reach out to us. A follow-up email will be going out after this webinar, usually within the next day or two. And that email will contain the recording of this webinar so that you can go ahead and watch it again if you want. It will also include any links that were discussed, and it will also include how to get in touch with us for additional questions. Thank you so much.